over to you.
Great.
He's got an hour worth of stuff for us. He wants it to be interactive, so take it away.
Thank you. Thanks, guys. My name is Lance Rogers, and it's an honor and privilege to be here with you guys. I'm an attorney, and if you could go to the next slide, Kathleen, we'll go ahead and give that a look. I've been practicing for 25 years. Hard to feel like it was yesterday I started. Hard to believe. But I have a very specialized niche in the area of real estate law. So how many of you remember the lawsuit between Nick Sirianni, the head coach of the Philadelphia Eagles? Do you guys remember reading about that around the time of the Super Bowl? Nick set new law in the state of New Jersey when he petitioned the court to find that a seller has an obligation to disclose a right of first refusal. How many people think that a seller does have a right, an obligation to disclose a right of first refusal to on a deed? Does anybody have an idea about that or never even thought about it? Never even thought about it. Well, guess what, Tom? You're not alone because the courts had never thought about it. There was no legal precedent out there until Nick Sirianni. And Nick Sirianni came forward and it was right after he was hired as head coach of the Philadelphia Eagles, and he put an offer in with my help on a property in New Jersey. And the seller failed to tell us that there was a right of first refusal on that house. And when we found out that there was a right of first refusal, we terminated the agreement. Now you might wonder, why would we want to do that? Well, the seller was not willing to remove the right of first refusal from the deed. They were waiving it, which had the meaning of the fact that the right of first refusal would continue on the deed, and any sales after that would be subject to the same right of first refusal. The right of first refusal was drafted by a very, let's just say, an attorney who was advanced in years and somebody who did not understand the needs of a right of first refusal, and he wrote things in this right of first refusal that basically made it almost impossible to transfer the property. So it would have had the impact of having the Giuliani buy a piece of property that they would have had a really hard time selling, which is why we terminated. The seller sued us for about $500,000 and said, you have to buy this property. And we won on summary judgment, and we set a precedent in the state of New Jersey and in the country, because Tom, we looked everywhere for a precedent on this issue and we couldn't find one. But there's now a holding in New Jersey. Judge Thickery said, sellers have an obligation to notify the buyer of a right of first refusal. In any case, yeah, go ahead.
Define right of
Yeah,
first
oh,
refusal.
okay, yeah.
So right if it's right.
Yeah, let me explain that. A right of first refusal on a property is usually something that goes on to title. Again, doesn't always have to, but usually goes on to title. And it says, before we sell this property to the buyer, we have to offer the property to a third party. That's a right of first refusal. And if you guys aren't aware or familiar with that idea, it's something you want to familiarize yourself with, because you should ask your sellers, are there any rights of first refusals that are active on this property? It's actually fairly common in commercial real estate. In residential, it does happen. So in this case, a very wealthy family owned the property. The kids now, the generation that was children, they're in their 20s, they were actually born in the house. The family didn't want to give the house up, but they wanted to sell it. So they thought by putting the right of first refusal, which obligated a seller to offer it to them to purchase, they would be keeping it in the family. Does that make sense? Yeah, Sean.
Could the seller even remove that without the third party agreeing to it?
That's a great question. So John's wondering, can the seller just remove that? The answer is no. The beneficiary of the right of first refusal, the third party, they would have to agree, and it would have to be removed on title. A right of first refusal that's on title mars title. It's an impediment on title, and so usually what happens is these instruments are usually around for one cycle, meaning that if it's not used, it's removed. And sometimes they're not even on title. Sometimes there can be a party, an agreement, a letter even saying, I'm giving you the right of first refusal on this property. It's not on title, but that's what title insurance is for.
Could it be in a trust?
It could be in a trust, but that wouldn't matter. So, and we'll get to that, I can talk about
So this was discovered when you did the title search?
It was discovered when we did the title search, and I went back to the seller's attorney and I said, there's a right of first refusal. She said, I'm aware, we're gonna take care of it, we're removing it, but they were only willing to waive it, which meant that it stayed on title. Removal means it's taken off title. Yes,
So how does, this is similar, well, is it similar to when we have sale settlement of another property with first right of refusal? Would that play into the same?
how have you seen that work out? In other words,
I personally have never had that in a transaction, but I know we have the form for it.
yeah, so yes, it would be the same. Here's what you guys need to take away. Whenever you get into a situation that has a right of first refusal, call John, call an attorney, call somebody and talk to them about it, because you wanna make sure, it's a little bit unusual, you wanna make sure it's covered, and that's the easy way to deal with it, cause it depends. I can't give you a single approach that's gonna govern in every case.
So we shouldn't advise our buyers if we're presenting, hey, sound settlement, first right of refusal, that contingency. We should probably talk to John a little before we say, hey, we're gonna present our offer this way.
Exactly, yeah, you're gonna wanna do that, make sure that you have somebody else who can guide you in that, and that's the easiest way to do it, right? And I'm always happy to take calls, and advise you on that, and that's pretty easy for me to do, but every situation is unique, so there's not a governing principle that I can tell you, this applies in every case. Did you have a question?
Yeah, I did. If it's a right of first, I'm just trying to figure out what the problem is, because if they refuse to buy it, well, then you get to sell it.
Yeah, but guess
So what's the
what?
problem?
What happens when the Soriani's gonna sell the property?
It's still there.
It's still there, and guess
Yeah,
what?
but if they go to sell it and they can say, do you wanna buy this house? And they say, no, and then we sell it to somebody else.
What's your name?
Gina.
Gina, you just put your finger on the problem. So the right of first refusal said that the kids, remember I told you there were kids? The kids have to waive the right in order to sell the property.
Right.
But there were no addresses for the kids. We had on good authority that one of the kids had some problems and was in and out of, shall we say, state institutions, and difficult to find, and was abusing drugs. So what happens if you don't get both kids' approval?
Oh, if you don't get the approval, you don't,
Bingo.
then
You
you
can't
just
sell.
can't do anything.
And you know what? It might take 6 months or a year to get their approval, so what do you,
Oh,
what
so
happens
there's
to the
nothing
buyer?
written in there that says they have up to 3 months to,
Exactly. Remember I
Oh,
told
then
you
you
an
can't
attorney who
change
was
that.
advanced in his years wrote this? It was really poorly worded, and so it was almost an open-ended check that really didn't give an easy.
so
word
who
out.
can remove that now? That,
As John said, only the beneficiaries and the owner of the property.
so the kids that are on drugs are gonna have to.
Exactly.
Wait, did you say it would say?
I had that actually happen to me.
I do.
I was selling a property in Chatsford, and it was a family that had owned a farm, and they built all these houses and all the family members lived in it.
Mhm.
One family member went insolvent,
Mhm.
and they decided they were gonna sell the house, and they were estranged from the rest of the family. There was an easement
Mhm.
as well. We went to put an offering on the place, and the family refused to take that clause away.
Mhm.
Plus, they refused to allow an easement.
There
So
you
we
go.
would have had, and it was, bound and, it's logged in, the houses were around it, they needed that easement.
Yeah, that's right.
So it gets tough,
Yeah,
and you have to be aware of that when you're actually putting an offer, or if you're listing the place.
yeah, that's
And,
exactly right.
yeah, that's, I had that.
Why don't we get back on track? We kind of dove into this a little bit, and I mentioned Nick Sirianni in the case a little bit to give you a flavor for what I do. I'm originally from Miami, Florida. I came up here to attend the University of Pennsylvania, got a master's degree at Penn, and went to law school at Northwestern, and then settled here with my family. I am a former commissioner in Lower Merion Township, which leads people to believe that I know what I'm doing with real estate. And ended up getting into the real estate industry right after I was a commissioner, because all these people started bringing me real estate work. I've been practicing in that area, like I said, for 25 years. Could we go to the next slide, please? Today, I'm pleased to tell you and discuss with you the top 10 mistakes I see being made on a daily basis. And I hope you guys can take something from this and learn from it. I very much welcome all your participation and questions, so please keep them coming. This is really good. But let's roll through these mistakes and see if people have questions about them, and if you can take something away from this presentation that helps in your practice. Number one, seller's disclosure. Quick show of hands. Is a seller's disclosure always necessary on residential real estate? Yes? How many people think yes?
No.
So there's probably that's it, yeah.
Okay, I'm hearing exceptions. How many people say no? Okay. So when would you need a seller's disclosure?
Person's dead and they can't fill it out.
They still have
Okay.
to.
It's a trick question and you're technically right, but here's the deal. You always are gonna have a seller's disclosure. And well, there's a box on there that says, I did not live in the house, I'm an estate administrator and I know nothing about the property. You have them check the box and sign it, yes.
Quick question on that, so I've run into this recently where if it is an executor, it's an estate, the listing agent will provide just page one, saying that that box was signed, will have the buyer and seller initial it, won't provide the rest of the 11 pages, cause they would have been blank anyway.
Correct.
And I've had some people say that that's okay, I've had some people say you still need to give the rest showing that it's blank with everyone initialing.
Yeah.
What do you think would be the more appropriate answer?
Go ahead and, okay, so the appropriate answer is, as long as they sign the first page and check that box, you're good. But I'm gonna tell you to go ahead and initial every page and sign it, and the reason why is because you wanna memorialize the idea that that person knew nothing.
Right.
And that's how you do it. Make sense?
Yep.
Yeah.
Kind of one other caveat there. Even though they're exempt and they sign in the box, they still have to disclose any known material defects. So
Correct.
I use the example of they're cleaning out their own basement, the thunderstorm comes up, water starts trickling into the corner of the basement. Well, they do have to fill in the section that says basement, have you seen water? So if you don't have the rest of the seller's disclosure, how do you know that there's not one thing completed on page 4?
Right.
Because they're not exempt from telling what they know.
John's exactly right. If they know something, they have to disclose it, just like you guys did, right? If you know that basement is flooding, you're gonna need to make sure that they disclose it properly, right? Because you're aware of it. Makes sense?
Yep.
Good. All right. When do we get the seller disclosure signed? Does it matter?
ASAP.
ASAP, which does it matter? Okay.
Before
It-
you submit an offer.
Before you submit an offer, what's your name?
Michelle.
Michelle is exactly right. And why? Because in Pennsylvania law, in the statute, it's actually written by the Pennsylvania legislature, it says you must have a seller's disclosure signed by both parties before you go under contract. That contract is technically not enforceable if you don't have a seller's disclosure signed by both parties. I typically, when I do some real estate work, if there's not an agent involved, I will always have the seller's disclosure memorialized on one day and then the agreement of sale the next. Just to alleviate any ambiguity as to whether or not one of the parties can say, well, I didn't see that until after I signed the agreement of sale. Go ahead and have the seller's disclosure signed and have it provable that's before the agreement of sale. All right, any other points on this one?
Two quick questions.
Yes.
I just help buyers to get a home, foreclosure home. And it was sold by a bank, bank says we don't have a seller's disclosure, and we have to do that.
Yeah.
What happened there?
So they should technically still have a seller's disclosure and check the box that says that they have no knowledge of the real estate. And what would happen there is that if, God forbid, your client decided that they wanted to terminate and that they refused to give a seller's disclosure, they could probably have a right to terminate. Right? But in your case, they wanted to buy it, it's a foreclosure sale, so maybe you look the other way, but realistically, it gives you a client now. All right? The bank wouldn't be able to then argue, oh, we didn't give you a seller's disclosure, we're not gonna go ahead and close the deal because they're the ones you recruited.
What about the people that don't fill it out correctly and there's that page where it says the following have problems or do not have problems and you know, you never fill that out and you bring it up to the listing agent.
Yeah.
And it's just,
You're gonna counsel your client on how to fill it out and make sure that to the best of your knowledge, it's done correctly.
well,
And
what if I'm the buyer?
you're on the buyers, you're gonna go back to the seller's representative and say, hey, you know, let's be clear here, and you can do it in email, so it's memorialized. But I get what you were saying, and it can sometimes be a weird point. Michelle, the other point that I'd like to make is, how many people think that if you sign a seller's disclosure and provide it, you're done? Nobody good. All right, so you have an ongoing obligation to disclose things. Let's say you sign the seller's disclosure, and let's say you use John's example, you're down in the basement, maybe doing something, and you realize there's a leak. Do you then have to notify the buyer? You have a buyer, you're under agreement? The answer is yes. I'm seeing a lot of nodding, that's good. Yes, you have an ongoing obligation. It says it right in the seller's disclosure form. You have an ongoing obligation to notify the buyer. And if you don't have a buyer, if it's not under contract, have them fill out a new seller's disclosure. right? Let's go to the next slide. Thanks. All right, this is the second biggest mistake I see in the sale of real estate. Drafting the agreement. We all use ZipLogic. How many people? ZipLogic forms the automated system by which you fill out agreements of sale. It's called ZipLogic, at least mine is called ZipLogic. The first mistake I see all the time is an error in the buyer's file. Why does that matter?
It goes on the
The
It goes on the
deed,
deed.
the title,
You guys are
the
educated.
taxes.
This is great, yeah. So you're submitting the agreement of sale to a title company. My wife and I own the title company. We see this all the time. You get the wrong name. Why does that matter? The title company runs a search, a judgment search. If we're searching the wrong name and the day before closing, usually the realtor comes to us and says, well, hold on, wait a minute. It's actually the wrong name. It's this name. We have to do the judgment search again. We have to do a lot of things over, and that's an issue, right? Also, if God forbid the title company doesn't catch it, the wrong name is down. So this is a big deal on the agreement of sale. We see it happen all the time. So pay attention to it. Yeah.
Sometimes, like, I get a client that's, like, her name had her original maiden name and her married name as her on the records, but she didn't wanna use that for her. Like, she was annoyed, she was like, I don't know why that realtor ever put I've never used that name in years and years. So like when you're writing the new agreement, her current license is different than maybe the house deed.
So
How
here's
do you
what
work
you're
all
gonna do.
those different parts? Cause your next, she doesn't want to, her license shows a different name.
You're gonna use the name on the license, and if she's telling you, look, I'm getting a divorce, or maybe I'm changing my name because I just got married, or I'm changing my name, or I wanna use a different name on the deed, alert the title company and let them work it out with her. All right, but you're gonna use the name that's on the
The
license.
name that's on the license is the actual like name. So if on the license they don't use a middle initial, then you don't use a middle initial. Is that right?
Correct. And
Okay,
if the title company wants a middle initial, they'll contact you or your client and they'll work it out.
cause I never thought to ask for a picture of their driver's license.
The title company's gonna ask at closing, right?
Yeah,
So
so
they're
I
gonna
think
see
that's
that.
probably a good thing to start.
Yeah.
People.
She has a birthday then.
Yeah, that's true. The next thing I see on ZipLogic and filling out the agreement of sale is that people always try to manipulate. They only give you like 100 characters. Fill in, whatever it is you need to in there. Don't play that game. Don't try to fit in whatever you need to into that small box because you're amending the agreement of sale. Use paragraph 32. It's there for a reason. It's at the end if you need to do it. I did it yesterday. Somebody wanted to change. How many of you have noticed that ZipLogic is not as flexible as it needs to be? Sometimes you can't even change the numbers that look like they're changeable. Are you guys seeing that as well?
We use it different ways.
Oh, you do? Okay. Which one do you guys use?
Stop doing zip form and DocuSign.
ZipForm is same thing that I'm talking about. Yeah, ZipForm. So sometimes it's a little wonky and you can't change the numbers. It seems so go down to exactly, yeah. So go down to 32 and type out, paragraph 17 is hereby amended to reflect 5 years instead of 10. Okay, don't use I see a lot of mistakes because people use, they shorten words and they try to just fudge it and it never ends well and there's an issue. The other thing I see is a lot of freestyling and people are writing things into it. And talk to an attorney. If you're trying to memorialize something, it's worth the 5-minute call. Talk to an attorney, try and get some guidance, or talk to John or somebody, just bounce it off of them because that's where I see a lot of issues arising. Let's go to the next slide. All right, this one's great. Zoning laws. So what's your obligation to be on top of zoning laws? I want to share a story with you because it really happened and it kind of illustrates the issue here. I had a client who was selling a piece of property in Ardmore. Actually, my client was buying the property. The seller represented in the MLF that it was subject to, the zoning would allow an office use, right? The buyer told his real estate agent over and over and over, I want to put my office in this building. The real estate agent relied on the MLS and said to him, you can do that. And he was an attorney. He asked the real estate agent over and over, are you sure I can put my office in here? And The real estate agent said, yes, you can put your office in. And the real estate agent was correct until Lower Marion Township amended the zoning, which happened during the agreement of sale period, to remove office use. So what does that tell you?
Wow.
What's your obligation?
Check it every day.
Well, okay, so Tom says check it every day, but I don't think you have to be that crazy, but it's not, I mean, you know, it makes you wonder, like, what should I do? The first thing you need to do, yeah,
Contingent on zoning.
well, you could do contingent on zoning, but that might spook the seller, and in this environment, you don't wanna lose a deal, right? So here's what you could do. The first thing is, don't ever trust MLS. Okay, I'm gonna tell you that right now. We'll see another story I'll share with you that shows you don't trust MLS. Always question those facts. But do you think if the realtor, who had been asked a dozen times by her client, can I have an office in here? Do you think it would have taken her much time to call the township and verify that? No, it wouldn't, right? Maybe a 5-10 minute telephone call. And if it's that important to the client, why not do it, right? Now, if the client hadn't said anything about an office, who cares, right? Because he hasn't told you that. But when he's telling you over and over and over, I want an office in here, and you see the zoning allows it, but you just wanna make sure because it's that important to the client, maybe you make that telephone call.
Would it be better if we had the buyer call, because I've always been told to be the source of the information, don't
Yeah.
intervene.
It would be better to have the buyer call, and I'm envisioning a buyer's agent calling. The seller, just be careful about what you're representing. So that's the other thing. Seller's agent represented in the listing that it was permissible for office, and she was right.
And had either of them called, maybe at least it would have came up, you know what, technically it is today, but by the end of the week, it's not gonna be. Maybe,
Exactly.
and maybe it wouldn't come up, but at least you say to defend yourself, I even called and verified something, you know, that's what you said.
Exactly.
They don't
John's
change
exactly right.
us, they don't change the zoning laws overnight, so.
Correct, and that was my next point. You're exactly, what's your name?
Janine,
Janine is exactly right. You told me that, sorry. Janine is exactly right. They don't change zoning laws overnight. And guess what? This realtor, she held herself out to be an expert in Lower Merion. She held herself out to be somebody who's wired in the community. Well, guess what? As Janine said, they don't change zoning laws overnight, and it was advertised over a period of 6 months. They were saying we're amending the zoning in Ardmore.
So how did this play out, and was there any liability on the seller's agent?
Yes, there was. And they settled because they made a representation that he would be able to use it for office. Not that the current use was office, but that he would be able to use it for office. See the difference? Current use versus what, or current zoning versus what he would be able to do. And she could have, I'm not talking about the seller's agent, I'm talking about the buyer's agent. She could have paid attention to zoning changes. If you guys have a geographic area that you specialize in, read the newspaper in that area. Stay in tune with the changes that are happening because they will impact it, all right? So stay up to date on the zoning laws in your specialty areas. Next slide. All right, can we rely on the MLS? I think we covered this one. Have you guys had experiences where the MLS doesn't work? Okay, let me share a quick one with you, which you're gonna love. And this is ongoing litigation right now, so it's in the court system, but I have a client who, and I have to be careful what I say about this because it is ongoing. I have a client who was buying a house in Lister, and let's just say that the square footage of the house was represented in MLS at a different square footage than the house actually was. It happens all the time, so be careful and don't take MLS at its word. If you have a client that says to you, I need a 9,000 square foot house, and MLS says it's 9,100 square feet, and the client says to you, it doesn't feel like 9,000 square feet. Don't just believe because it says in MLS it is.
So, like, when we put a listing in, it asks what source. Are we not covered if we say it's from the public records?
When you say, when you put a listing in, you mean for the actual listing, you're taking
Yes.
information from
Correct.
MLS? So if you're taking information from MLS, let them indicate per MLS,
Yes,
and you're good.
okay.
You're good. You're reporting what MLS is reporting.
I report what public records have been pushed down, and, you know, if it's wrong, That's why I don't think the
Unless you know
client,
different.
yeah, unless I know different,
You're
yeah.
gonna say something different?
Yeah, I would even say
As
if you
per
suspect
MLS.
differently.
Because
you
agent
can
remarks.
put it in the
Because,
remarks.
okay, because of
Or even,
Please verify.
Buyer verify their, actually.
Listing.
That's a great idea.
Was
We all hear what John said.
That's-
Yeah.
buyer's responsibility to verify.
I've seen that.
Yeah, because MLS is wrong frequently, and so when your clients come to you and say, if you're on the buyer side, hey, it doesn't seem this way, don't just take MLS's word for it. The other thing, is John just said, if your client comes to you and you're not sure, you can put a remark into the listing that just says, please verify, you're not sure.
Into remarks.
Agent remarks, yeah.
That's why I see them buyer to verify.
Yeah, I've not thought to do that.
Do we have access to agent remarks right after it has settled? Because would you see that if you needed that for evidence a month later? Well, I told you guys.
That's a great question.
Print it out.
Everything that is online is saved, so yes, eventually a subpoena will find it.
Yeah,
Is that your question?
yeah, like what we recovered if we just put agent remarks.
Sure, it's always discoverable.
Okay.
All right,
You could
this one's-
also
Or just
download a copy and
of
save
their
it.
MLS.
And save it.
Their MLS and save it.
Yeah.
I've been taught to do that.
We're supposed to be mean.
Let's go to the next slide, please. Just put it on your listing. Thank you. Next slide.
Sorry,
Okay.
I was just asking if you find it to be wrong, is there a process for updating it?
In MLS,
Or, yeah, public records or?
I don't think you're gonna have much luck getting that done through the county, but if you make a remark, as John had talked about in the listing, that's your best bet. And obviously mentioning it in writing and orally too, if you're on the seller side, to the buyer's agent that comes to see the house, and then if you're on the buyer's side, obviously tell the seller's agent, hey, there's a problem.
And be very careful about being the source of whatever that number is, because you got 10 people measure a house, especially, this is a great example, you get 10 different square footages. The point is, it's gotta be out there that this may not be accurate.
Yeah.
Who's to say what the final accurate number is, but
That's
there's
just
three families, lawyers.
I've also seen problems with MLS on zoning. They don't just take MLS's word for it. So like I gave you that example before about.
So do you recommend us calling the township to see what is on there?
Yes, if it's a zoning issue, call the township. They are more than happy to talk to you about this and be a resource for you. But there's a lot of different information that's gathered in the MLS. So depending on what it is, you know, approach the county, the township, or, you know, seller for information. It's always a good idea to do your diligence and check up on. All right, let's go to the next one. Offering legal advice. I think you guys all know that you shouldn't be offering legal advice, but sometimes you might be offering legal advice and you might not be aware of it. Let me give you an example. Hey, I'd really like a house with a swimming pool. And then you say to them, well, you could put a pool in here. What's the problem with that? Without knowing
You
it?
don't, there might be a septic, there might be a well, there might be a, you know.
Exactly, you might be over
underground
on
wire.
impervious surface coverage and there's not a swimming pool allowed. There might be some weird thing in the deed that says, you know, any future owners of this property may not construct swimming pools. You never know, right? So be careful when you're making those representations. I know that you're trying to be helpful, but just keep in the back of your mind, they might rely on that representation to their detriment, and then I've given legal advice. Does that make sense? It's pretty straightforward. I think you guys are all nodding. This one's pretty straightforward. I see it happen all the time.
We've heard it before too.
I'm sure, yeah.
Have you never broke it?
It seems pretty good. The one thing that you need to keep in mind is, when you tell somebody something, hey, you know, I would tell you this. If you want a swimming pool, I would go talk to a swimming pool installer and also make sure that it's permissible and the swimming pool installer can help you figure that out. Put it in writing. Why? Because the client isn't hearing you say that. The client is hearing you say, Tom told me I could put a swimming pool in. Tom told me to just talk to an installer and it was a done deal. And they hear things maybe not even nefariously, they just hear things differently. They got a lot going on, they're excited about buying this house, there's a lot happening, and they just remember things differently, and it's not even nefarious. So always just memorialize it. Hey, I know you really want a swimming pool. Here's what I would do. I'm not sure that it's allowed, but here's how we can figure it out, and just memorialize it. Right? Any questions there? All right, next one. Assignments, this is my favorite one, guys, because everyone gets this one wrong, all right? Pay attention here, there's one thing that you learned here, I bet it's gonna be this one. Assignments. How many times have you ever been with a client in a house? You got 3 realtors backed up behind you at the showing. You know this house is gone that day, right? And the buyer says to you, I think I might wanna buy this house in the name of an LLC. How many show of hands, how many people are, okay, so a fair number. And you say to the client, that's okay, we'll do it in your name and we'll put language in there that allows you to assign it, right? I see you're shaking your head no.
It's deed issue.
It's a what issue?
Deed issue.
It's a deed issue, but the bigger issue, that's right. The bigger issue, and I heard John say it, bigger issue that no one knows about, I see people get this, lawyers get this wrong. It's a transfer tax issue. It's a double transfer. So the Department of Revenue in the state of Pennsylvania has said, and this is kind of tricky, but what they've said is, if you assign an agreement of sale to an LLC that was not in existence at the date that you put it under contract, you're gonna pay double transfer tax, which can be a very costly mistake, as you guys can see. In lowest, it's 2%, highest, we're tipping towards 6% in Philadelphia, and guess what, weddings at 8 or 9? Yeah. So you need to be really careful about this. If your client is talking about assignment, your best bet is to say, hey, I'm gonna put this, we need to get this house now, we need to grab it. I'm gonna put some assignment language in there. John Doe and his assigns, and we need to talk to an attorney. Here's what we can do, attorneys can help in this. We can file and draft something called a novation, okay? A novation has the effect of transferring the property into the LLC's name, or the agreement of sale rather, into the LLC's name without triggering the double transfer clause. The other thing I've done, and I actually prefer this route, is you get to the point where due diligence is over, you know your client's locked, you go to the seller and you say, listen, we're using an LLC to purchase. We want to replace the agreement of sale with a new agreement of sale, putting the parties exactly in the place that they are at the time that you have that conversation. Due diligence is over. The deposit is still there. You assign the deposit to the LLC and you enter into a new agreement of sale with the same closing dates and everything. The seller, if they're smart, will want to do that. Why? Does anybody know? Because they're on the hook for double transfer tax as well.
Oh, are they?
Yes.
So it's
Not just the buyer.
When would that trigger would the title company pick up that double transfer tax?
They could, the Department of Revenue audits deals, and they could see that, and I don't know how they do it, but I've actually had a situation where they picked up on this and then tried to charge double transfer tax. So that's why you want to be really careful. They're really going after wholesalers, right? People who are flipping contracts. But in this situation, they go after, a family who wants to put it into an LLC. And I want to talk to you guys about LLCs in a second, but I want to take this question in the back.
Can they come for the double transfer tax like after it's already closed, or do they have to catch it beforehand?
They always come after it's closed.
Wow, that's
Yeah. And I still, to this day, don't know how they know what properties to audit.
Yeah.
Is there a time limit that they can go back though?
The statute is probably 4 years.
Oh my God.
Yeah, so you can get a knock on the door from the Department of Revenue saying, we found out. And I don't know how they end up doing it. I don't know if they audit. You guys ever have audits where they look at the agreements of sale that you have? But I've seen them figure it out, so you wanna be sensitive to this. Do you have a question, Bob?
Yeah, so if you're gonna do that second scenario, what's the best practice for, you don't wanna be out of contract, say, all right, we're gonna terminate this one, and then this afternoon, we're gonna sign the new one. There's no guarantee the buyer or the seller is gonna sign that, you sign the new one, or you terminate the old one.
John just made a really important point that we need to stress, and that is if you're gonna use that second scenario, you don't do anything with that first agreement because you'll be out of contract or you'll take away a deal and you'll give the seller all the leverage. So you wanna sign the new agreement of sale and then destroy the old one. So that's the way it works. Or you don't wanna put in the agreement of sale that we're destroying the prior agreement, because that doesn't, right? So what you say is, we're gonna sign the new agreement of sale, give that to a title company, and then you just destroy the old one, sign for it, and you can sign it from me. Yeah. but it's usually just a complaint.
What
It's the
happens,
same agreement.
what happens when you have a seller, just he's on and the closest to Saturday, a week before, you know, we're not gonna put her on, my girlfriend's gonna,
Yeah.
she's not gonna be on the mortgage, but she's gonna be on the deed, we're gonna add her to the agreement of sale. Does that play in
Great
there?
question. So she's asking about what happens when somebody, the week before settlement, adds a person
Yeah.
to the deed. Well, guess what? People don't count. So according to the Department of Revenue, if you add a person, you're fine because they were in existence at the time that the agreement of sale was drafted, right?
They
What
were
if
born
the-
that day.
Okay, what about one LLC name changes to another? Would that count?
Okay, so if the LLC that is in the agreement of sale was not in existence on the day that the agreement of sale was drafted, then it would be a double transfer.
Cause I had about, when he had an LLC, and then he was like, I'm gonna create one new contract. 2 weeks later, I created a new LLC, and we're doing that with my cousin, we're gonna change it into that.
Yep,
So that's
yep.
great, so they could get hit with,
Exactly, double transfer tax.
so glad I came to that.
Do you guys ever wonder why sometimes you see people putting language into agreements of sale that say, if it results in any additional fees or charges, then the buyer will be responsible or seller will be, this is wrong. They know about this. This is why, did you have a question in the back? Did someone-
I did, but it got answered.
Okay, good.
Thank you.
So this is, the bottom line is that if you hear LLC or transfer, call an attorney, call John, call somebody, because you could inadvertently trigger a double transfer. I have, in my 25 years of practice, seen maybe 2 or 3 people that are aware of this. I know because it happened, right? It happened to me early on in my career, and I know that it exists, and I went and read the Department of Revenue, they issue opinion letters, and it backs this up. It was, I think it's from the 1990s, yeah.
So just to be clear, this is only applicable if the LLC that you're assigning the agreement of sale to did not exist. If a buyer buys it in their name, they're like, you know what, that LLC that I've had established for the past couple years, I'm just gonna put it in that, then this isn't applicable because it already existed.
Correct. What are you gonna do though in that scenario to protect yourself?
Probably still put something in writing
Right,
about it, yeah.
right. It's my understanding, John, sorry to pick on you, that the LLC was in existence. And by the way, you know, if it was not in existence, there could be a double transfer tax issue.
Still
Now,
disclose it, yeah.
you've done your duty as a realtor, right?
Yeah.
Made them aware of that. All right, why do we use LLCs? Anybody know? What? I get this question all the time. What is it?
To protect them from liability.
Michelle's exactly right. Protection from liability. You don't want your client to be liable. When would you want them to be protected? Because I don't own my house or an LLC. When would you consider using an LLC? With an investment property, if they're not living in the property, maybe their daughter's living in the property for college. Maybe their relative is gonna live there and they're just giving them a place to live. If they're not living in that property, they're not controlling it. And if they're not controlling it, they can have a huge issue with liability. Now, a lot of people say to me, well, I just went out and bought another $1 million on my umbrella policy for insurance. What's the problem with that?
Tenants insurance.
You have tenants insurance? Sure.
You get
Insurance,
sued for $10 million.
you can get sued for 10 million. That's exactly right. Tom's right. But insurance doesn't cover everything. What doesn't insurance cover? Willful acts. So if I went outside right now, I have auto insurance. If I went outside right now and I got in my car and I purposely slammed it into John's car, again, would my insurance cover that? Probably not. When they found out that I purposely slammed, I mean, when they found out it was John, I'm probably like, okay. But if I purposely did it, insurance doesn't cover. So that's why you always want to consider the LLC when they're not living in the property. Not controlling it, you know, you wanna have some more protection. The LLC, think of it as a one-way valve. Liability does not go up. So when you own the LLC up here and the property's down here, liability does not go up, right? That's why. Now, a lot of people say to me, trust, LLC. I'm a fan of LLCs because trusts don't give you the same protection, all right? And I'm getting way into the weeds here, but if somebody starts talking to you about this, you know enough now to be dangerous. Get them to an attorney, tell them about the parameters that I just shared with you, get them to an attorney so that they can best be protected and you can be protected.
Same thing with a flip house, you put it in recommend they put it in an LLC.
Absolutely, and the benefit of putting a flip house in the LLC is they can buy the LLC and not the property. And a lot of municipalities have not passed the new legislation which says that if you buy an LLC, you don't pay transfer fees.
What?
Yeah, think about it. This doesn't work in Philadelphia, don't get too excited. It doesn't work. There's actually some state legislation that's floating around right now, but think about it. If I own XYZ Corp and XYZ Corp owns, say, Suburban Square, true story. Suburban Square was owned by an LLC. And when the entity that owns Suburban Square now bought it, they didn't buy the real estate, they bought the LLC. Back then, they didn't have the legislation that they're now implementing, and they skipped paying transfer tax on that property. Now, how much money do you think that was? Several $1 million. That would have gone to Lower Merion and the state of Pennsylvania. My wife was the leasing director at Kimco, the entity that bought it, and I can tell you that the township, Lower Merion, I was a commissioner at the time, the township was not very happy about that. But now they're starting to curtail it, and there are certain requirements, like you can only pass 20% of the property per year for 5 years, and things like that, but that's another reason that you might wanna have a flip in an LLC.
Question about LLC. As a realtors, should we get ourselves an LLC as a realtors?
So,
Yeah, and and that entity, some of us are all investment properties. Can we cover under the same?
okay.
Working as a realtors and investment properties.
Those are great questions, and I would say that in order to talk to whether or not you should have an LLC, I would talk to Cindy or John about whether or not how Keller Williams works with LLCs. The rest of your question I can definitely answer, and the clear answer is no. You never want to put liability causing sources together. I am a big fan of the silo option for LLCs. My wife and I own, I don't know, 7 or 8 parcels, 7 or 8 pieces of real estate across the Commonwealth. Every single one of them has a separate LLC. And the reason being is that I know that if I have a disaster at one of those properties, the worst thing that can happen is that I lose the property. And it doesn't impact the other properties. So let's use your scenario. If you're using an LLC to buy a property and to be a realtor, and you get sued, God forbid, for malpractice, which you're not going to after this presentation, but let's just say God forbid you get sued, you can lose that property in the LLC. So don't put anything in that LLC. You're just using it to absorb liability. Any questions on that?
So if you have an LLC that our real estate is, we're using that through, do not use that LLC to purchase property.
Correct. Yeah, and even if you do use a separate LLC to buy property, which I'm a big fan of, don't buy 2 properties in the same LLC.
So it'd be 123 Main Street LLC.
Right, that's right. And then when I buy the next property, so I always like telling my clients to use the name of some, bizarre name. I don't name it 123 Main Street anymore because I know that sometimes deals fall through. And now,
Oh, okay, yeah,
even last week.
can't use 123 Main Street on.
Or 123 Main Street.
9
Yeah, that owns 123 Maple, yeah, exactly. So, I have clients, by the way, to skip that whole problem of assignments, start their LLCs when they start the purchase process. And they come up with a unique name, they name it after their children, and they have the LLC ready to go. So when they go under contract, they just write the LLC's name in there and you're good to go. And then when we look for the next property, we form an LLC. Now, I started this conversation by asking you, what is the purpose of an LLC? And I think it was, Michelle said, liability, and she's exactly right. There's another purpose of an LLC. What is it? Anybody know?
Taxes.
Taxes, I don't know. I'm not an accountant, I'm not sure. Okay. Secrecy, anonymity. I represent a lot of athletes in the Philadelphia region. I just told you, Nick Sirianni. The NFL requires me actually to go out and form an LLC. A lot of the Eagles, when we're just losing, AJ Brown, I'm his attorney. When we buy houses, we don't want people on our doorsteps on Monday night after a bad football game. We do it for anonymity purposes, okay? Sometimes our clients don't want their neighbors to know who they are. Sometimes they don't want anybody to know who they are. Talk to an attorney about that because with today's technology and the new requirements under Pennsylvania law, there is a disclosure issue and you need to know how to get around this. So I was Claude Giroux's president of his house for 7 years. Cause he bought in New Jersey and you have to deem an officer to the house, so I was his president, I actually was the president of his house, which is kind of weird. But yeah, so there's ways around these things, but just talk to somebody who knows what they're doing, right? Next slide. Deadlines. Do we all have systems set up and monitor deadlines?
Yeah.
Okay, I remember early on in my career, I was representing a seller who wanted out of a deal badly. And we got out of the deal, but the way we did it was through a deadline. I'm sure you guys have seen this before. It's the mortgage commitment deadline, right? And we all know about it, and guess what? The realtor in that deal had the mortgage commitment, they just hadn't forwarded it to the seller. So we waited up at 12:01 on the day in question and said, you failed to get us the mortgage commitment, we're terminating, and the realtor had to own the liability there because they sat on the commitment and didn't get it over to the seller in time. Had they realized my deadline is today, they had it, they would have just forwarded it over. But don't be a victim to this one, monitor those deadlines. I think that's pretty self-explanatory. Any questions on that one? I see this happen a lot. Yeah, you're busy, I get it, I'm busy, it happens, just pay attention to those deadlines. Yeah, what's your name?
Bridget.
Bridget.
So with like inspection contingencies,
Mhm.
so if you have a seller, the buyer's agent had mentioned at some point, hey, we need an extension on the buyer's upon inspection date. That date came and went, and they never sent the extension that they mentioned.
Mhm.
They come back the day after the original due date, they're like, oh my god, I'm so sorry, hey, forgot to send that over, here it is, like, hey, in good faith, can we all just like, oopsie, do it? If the seller says, fine, and they sign it, and everybody signs it, even though they both signed the extension after the original date you're extending, is that still technically valid?
So Bridget's asking whether or not there was a waiver of the fact that the original due diligence deadline expired and they memorialized it afterwards, and the answer is yes, that's fine. The parties have chosen to waive that lapse.
Okay.
But I thought you were going somewhere else, I just had this happen. I just had an example where I had someone come to me and tell me that they were under contract in New Jersey, and it was kind of it wasn't the standard agreement of sale in New Jersey. And they did their due diligence and they found something and they were negotiating with the seller, and it didn't have those deadlines in it where you have 2 days, whatever. So the due diligence period lapsed, but before it lapsed, he said, this guy was representing himself, he was not using an attorney, I hadn't talked to him at that point. He said to the seller, I need an extension, and they talked about a potential extension, but never memorialized it. He's SOL, right?
Right.
It's a legal term, by the way. So, and that's the case because you need to have everything memorialized. Oral agreements exist, but good luck proving them. It's very convenient to say, well, we talked about it and you agreed. Just memorialize it.
Pennsylvania, statute says it has to be writing, or it doesn't.
The agreement of sale has to be in writing in Pennsylvania. There is some question about whether or not it needs to be in writing, but it's not this, you're absolutely right, John's right, the agreement of sale must be in writing, but in order to amend it, there's a question as to whether or not it's enforceable if you have a handshake deal, if you can prove it, that it's in writing, or that's, you have in the writing.
So in that same like inspection situation, so let's say the buyer's agent texted the listing agent, hey, we need this extension. And the listing agent was like, hey, that shouldn't be a problem. But nothing about the seller agrees, I talked to the seller about it, was just a listing agent saying that shouldn't be a problem. The date passes and the seller finds out and they wanna hold firm, hey, like, I didn't know, I didn't sign anything, I didn't agree to it. Is that buyer's agent SOL, or can they try to use that text of the listing agent as like written confirmation?
Most likely SOL, shouldn't be a problem, suggest that in the future they're willing to do it.
Yeah.
But you never know, if under a fact, either a judge or a jury might say, well, that kind of led them to believe that there was an agreement, and it is in writing, by the way, so it's on email.
Interesting.
So,
Text, right?
or text.
Yeah.
Text
But it also suggests that there could be a problem.
Exactly, yeah, Tom's right, so that's what the seller's gonna argue.
Right.
I didn't say it's done, I said it shouldn't be a problem, and so it's probably an 85-15, in favor of it not being an extension.
Okay.
All right, any other questions on that? Let's go to the next slide. All right, permits. the dreaded permit requirement. All right, I amend, by the way, if you ever work with me, I take the agreement of sale, the model agreement, and I amend it in multiple ways. And I do that specifically for a couple of reasons. First of all, I believe in getting, is time up? Okay. I believe in getting deals done, and I know that at the end of the day, that's our job, right? We want to get deals done. I'm not one of those attorneys that settles deals. I like getting deals done. And I know that if I use a fancy lawyer contract, that in this environment, if I'm a buyer's representative, we're gonna have a problem because the seller's gonna look at that and go, well, that scares me, right? I don't want to deal with that. So I always use the agreement of sale, the par form, the same agreement of sale you guys use. But that agreement is not perfect. There are some serious holes in it, and I fix them. One of the holes that I fix is permits. So the Pennsylvania Association of Realtors form is silent on the issue of outstanding permits. Actually, I think it has a representation now that there are no outstanding permits. What happens though, I add a clause in there that says something along the lines of, no permits have been closed within the last 90 days. Why do I do that? Why would I put a clause in the agreement of sale that says, that has the seller representing to the buyer that no permits have been closed in the last 90 days?
So you need the contractor?
Means contractor liens, tax reassessments, there you go. So, and liens is probably pretty close. What happens when somebody closes a permit? This might be insider baseball, but I'll give it to you. What happens is that the county sends their tax assessor out to the property. I cannot tell you how many times I get this story. I closed on the property, and 2 weeks later, this gentleman knocked on my door and said, I'm here to do your reassessment. And I let the guy in, I thought it was normal. And then all of a sudden my taxes went up 48%. Well, they went up 48% because the seller, who's probably a flipper, fixed up your property, closed the permits out, didn't do anything wrong, just didn't tell you that they just closed the permits out. And now the county is increasing because the property value went up, they're increasing taxes. That happens all the time. So the way that we guard against that is I put the language in the agreement of sale to fix it by saying no permits have been closed in the last 90 days. If they say that's not the case, then I say, well, tell me what you did. We figure out and we can set the buyer's expectations on taxes. Yeah.
I have a listing I'm working with right now, and they did a lot of improvements, they didn't get any permits.
So you're using the seller disclosure to disclose that, right? Truthfully.
That they don't say that, have to.
Because remember, there's that column that says, did you pull
Yeah.
permits, yes or no? And you're saying no, right?
Or unknown.
Unknown.
Or unknown,
Yeah,
but.
because you don't know if the township requires a permit.
Okay, but if it were me, and let's go back to the seller's disclosure for 1 second, because there's a point I did not make that I want to make to you, and it's really important. Number 2 behind the assignments. The seller's disclosure is your get out of jail free card. It is the one opportunity in this deal that you have to put everything on the table, and when you put it on the table, you're good. The buyer can't hold you or your client responsible for anything that you disclose. I am a huge fan of over disclosing. And in this environment, no one's going anywhere if you disclose, okay? So use the environment to your advantage. You've got a seller and you're representing them, and there's a seller's disclosure, and anytime somebody says to me, well, I'm not really sure, I did perform maintenance on that, fix the problem, I say to them, what's the problem with disclosing it then? Let's disclose it, and that way you can't be sued for it. Does that make sense? So always over disclose.
So if you explode and you say something about that grouping, or something, and then in the inspections, it comes up.
Mhm.
I disclosed it. You
Yeah.
said it was okay.
Yeah.
We shouldn't have to fix it, correct?
It's gonna come up regardless of the inspection. And in this environment, again, I mean, I see a lot of sellers going, hey, you want the house or not?
Yeah.
Like, the seller's inspection, we all know what the inspections look like. We all know that an inspector's gonna find something. And, I always just say, it's gonna become this, the inspector does not look at seller's disclosures typically before they do their inspection. So I would say there's no risk in causing an issue by disclosing it, and it just gives you a free pass on my opinion.
I think sellers, are afraid if they disclose something, someone's not gonna buy the house.
Yeah.
And we need to tell them, I very rarely, if ever, see someone not buy the house because of disclosure. But you putting everything on there and more, it's gonna protect you, so it's, you almost can't lose and you can own it.
That's right. 7, 8 years ago,
Still not disclosed, but
I would err on the side of disclosure, but I get it.
the fear of losing was there and it's
Right,
not.
exactly, yeah.
Yeah, so go back to the issue on the permits. There's so many things that sellers do that they should have gotten a permit for, decks and, major improvements.
Fencing.
What'd you say?
Fences.
Fencing, there's
Yeah.
many things that people do need permits for, but there's tons of things that people don't need permits for. So you have to know what they need a permit for. If they didn't get a permit, you need to make sure that they actually go get a permit. You don't want that to happen. If there's a UNO inspection, then that's gonna trigger the township inspector to come out and go, oh, I didn't know that you converted your garage to a bedroom, so that required permits.
So
So
they did it like many years ago. No, my client, she had to change it back to a garage.
Wow.
And why is that? Why did she have to change it back to garage? Which township?
That was in New Jersey, so, and I wasn't involved, but she told me that.
That usually happens when, and I can tell you this as a former commissioner, when somebody doesn't play ball and is difficult with the township.
Oh.
So if the townships have badges that they love to use, but if you're respectful to them and show them respect and work with them, they very rarely will require that you undo work. They'll work with you to make sure that it was done right and then move on. So it's all about how you handle the township.
And then back to the my thing was, and John, I'm sorry, I just jumped in late here, is we have a lot of flippers in this area, so many. And that is huge, because we're hearing about that people are buying a house that's been renovated, want to put $50,000 or $100,000 into a house and do a flip. That's huge, to add that to your contracts.
Isn't that why, I think it's an FHA loan, they can't get a loan for a home that's been flipped in a short period of
It's not
time?
90 days.
90 days,
Can't break it
yeah.
down within 90, yeah.
In
Do
the
appraisals.
And so that could be related, right?
Could be.
Yeah, but it's the tax impact is the issue. I mean, if someone goes in and completely, renovates the house top to bottom, and the house had really been, quarter house, let's say, for example, you see a lot of those as well. There's an issue.
We see it all the time, it happens all the time.
The strange thing about the agreement, you're talking about the reassessments, 15A says, and I never knew why it said this, in the event any notices of public and or private assessments as described in paragraph 10F, excluding assessed value, are received after the seller has signed this agreement and before settlement, seller will within 5 days disclose the notice.
Yeah.
It says excluding assessed value.
Yeah.
Why would it exclude that? That seems to be
And
the
that's-
most important one.
And that's a new provision in the park, that's new, and they just don't get it. There's
The builders have like strengthened their lobby.
It's, and it's the one thing your client really wants to know.
So it's important that you
right?
exclude it.
Exactly, they're building a budget, and if taxes are going up by 50 or 100%, I mean, we see this
So
sort
the
of stuff.
seller doesn't have to tell the buyer, while they're under contract, they get a notice that they're being reassessed.
Correct, I would argue that they do have an obligation to tell the buyer, but obviously it's
I
excluded.
think it would be a bad idea to use this as the reason not to tell.
Correct,
Hash it out.
correct, yeah, but it is the case. And by the way, guys, that power agreement, and I hate to be so negative on something, it is not great. It is not great, there are holes in it, why? Because it tries to be fair to both sides, right? And whenever you do that, you end up disadvantaging somebody unintentionally. So I fixed the power agreement in many ways, and this is one of them, and they still, that committee, and I talked to somebody on that committee, they still haven't fixed that problem.
Do you just strike out that part?
No, I put something in paragraph 32 that says, no permits have been closed in the last 90 days.
Okay.
So that would cover this.
Yeah,
So we should write that in under the additional.
you can,
That's
but,
not easy.
there's a lot of those, yeah, so you can definitely have that. Any other questions on permits? How are we doing on time?
We're just about running out.
Okay, so let's keep going, I wanna get through these last two pretty good. Written communications, so this one's pretty straightforward, but you guys need to realize that as realtors, there's a lot of situations that I've seen where people say, you know, my realtor told me I could put that swimming pool in, we'll go back to the old example we were using. You need to think about your communications and how you memorialize things with your clients, okay? You don't need to write them a lawyer letter, right, Bridget? So you don't need to say like, you know, we have an agreement to do this or something, but there's ways of gracefully memorializing things in email, and that's what you need to be doing. You know, thanks for taking the time to talk to me. As we discussed, we just secured an extension on due diligence by 2 days. That means our deadline is 11:59 on Tuesday. Bang, done. Your communications with your clients are not privileged. That means they can be grabbed by subpoena, they can be gotten in a litigation. And here's a mind-blowing thought. What happens when Bridget memorializes and I'm picking on Bridget now, the extension of due diligence? She memorializes the fact that the seller has told the buyer that they're planning on moving out on Thursday. She memorializes everything about the deal, but she didn't memorialize the fact that something else happened. What happens?
It's assumed that it didn't happen.
Bingo! So you need, and I'm not telling you this to dissuade you from memorializing things, I'm telling you this that you can unintentionally create a record that suggests that you never told the client about something. So if something's important to you, remember to memorialize it. Even if it's a week later, it's not a big deal, just write the email. Hey, remember when we met at Dairy Queen and had those great Sundays and I told you that? Yeah, you can do that. You can do that. And I'm sure you guys are smart, you'll figure out a way to do it gracefully so the client doesn't feel like you're blurring the file, okay? Because that's a bad feeling when you get that sort of email from your realtor. All right, any questions on memorializations and communications? Your representations are binding, just remember that. You say something, maybe you say it to be nice, supportive, just remember that you're a professional and they're gonna hold you to that standard. All right, let's go to the next one, the last one. Dual representation. How many people have ever done dual representation? It happens, right? The key to dual representation, the risk factor is through the roof. I do it sometimes, I'll tell you that, but here's the key to it, know when to get out. When do you get out? What is it?
I said, when you keep hitting your head against the brick wall.
When you're accused of,
Well,
when they start questioning.
hopefully you never get to that point. So Gina's saying that when you get to a point where they call you into question, hopefully you never get there. And I'm sure, you know, you guys have seen this. You want to bail on dual representations the minute an issue arises that you don't feel you can be fair on, right? So the buyer tells you something and you know the seller's not going to like that. You might have a conversation with the seller about it, and as the feud starts erupting, you say, I have a conflict now, I'm going to recuse. Now, what do?
Get another agent in the office.
You can do that, that's a great idea.
Take the listing side.
What's that? You remember my memorialization, you wanna go back. Technically, the right move is to take yourself out of the deal altogether, but if you go find another realtor from the office and say, hey, Peggy's gonna now represent this side and I'm gonna continue to represent this side, you get them to agree to that part. Okay, you can send them an email. Does that sound fair to you? I think both sides at this point need representation of an experienced realtor. I've introduced the other side to Peggy. Peggy's gonna represent them. Is everybody comfortable, and by everybody, I mean both parties, buyer and seller, with me representing this side still?
I have a quick question. So in this state, when I was in Massachusetts, I was able to represent the seller as a client, but the buyer was a customer. So I was, and I explained it, I wrote it out, you're a customer, I'm, he's my client type of thing. So can you do that in the state?
I've never seen that done, but I don't think that would change anything, because you would owe a duty to both, and that's where the dual representation threat comes in. When you have a duty, remember, you have a duty to disclose things, you have a duty. Here's another classic breach of that duty. When the buyer comes to you and says, or the seller better yet comes to you and says, oh, don't tell the buyer, but that should set off an alarm bell in your mind right away, right? You know you have an issue. Don't tell the seller, but don't tell the buyer, but. So that's when you have to stand down. So that's, when you have a dual duty, it's the duty that gives rise to the problem.
Okay, got it.
And it's a high level of scrutiny. If you ever go to court when you're representing both sides, you got an issue. All right? So why? Did you have something? Sorry.
I do, I don't know, on this, you have something on this question?
That buyer told you something that you, okay, I don't like that, now I've handed that over, and now you're just representing the seller, and everybody's agreed that. Then you tell the seller, this is what the buyer said.
That is a great point, and I need to be clearer than I was, because I obviously didn't make it. When the seller tells you, don't tell the buyer, but you're only representing the seller at that point from now on. Okay, you're done with the buyer, because you now have things that the buyer shouldn't know and that they shared under the realtor client privilege. There is no such privilege. I'm only
So you can share what was said before when you were under that privilege with the buyer.
So you need to be really careful you now are only after the parties have released you and said, that's okay, you can still represent the seller and Peggy's gonna represent the buyer. I don't know who Peggy is, but when that happens, you now have a duty only to the seller. And my advice to you would be not to repeat what the buyer has told you, only to go on what the seller has told you, because you did have kind of a conflict that arose. So you just stick with the buyer and try and keep you just stick with the seller and try and keep the buyer's comments to you to yourself. All right, Cindy, I think.
So I know these were not up on there, but I wanted to talk about. What about agents who can't help themselves and they're very helpful people and they start helping the seller, they're finding contractors and they're helping them move and they're cleaning their yard and they're taking, taking their trash out and they're they're doing all these levels of support that are not in our professional duty. Where's the liability there?
Okay, what you're talking about is the realtor has stepped outside of their scope of employment with Keller Williams, okay? Because they're basically doing something outside of here to help in the deal. The problem with that, and this is why I'm gonna tell you don't do that, try not to do that, is that the court is going to look at your actions and try and determine, do you have your realtor hat on or you're just being a good human hat on? And sometimes it's a gray area, sometimes it gets really close. I just tried a case a few weeks ago and that exact issue was at play. It comes up a lot in new construction. And sometimes the realtor can cross that line and then do something that, creates liability. You have to always assume you're wearing your realtor hat and you're subjecting Keller Williams and yourself to liability.
Come over and I'll paint your living room for you. I mean,
it sounds ridiculous, and Keller Williams is not sending you into that living room to paint it, but it opened the door for that person, that buyer maybe, to sue you because let's say something happened when you painted that living room that caused liability. It opens you and Keller Williams up to liability.
Could you be a resource?
Yes.
Why would you pay it? Your client would then pay it.
Yeah, you can be a resource. You're talking about referring to professionals.
Right.
Yeah, I'm not aware of any findings that suggest that you're responsible unless there's a nefarious purpose. Let's say that you refer somebody to, a contractor that your husband owns, and you don't tell them that. That's an issue. But as long as you're being straightforward and telling them, hey, I've used this contractor, and I typically like a rule 3. Give them 3 options, or if you only have 2, give them 2, and say they're both great. Good luck.
I'd say they have been great for me up to this point for whatever it is, 2 years, 10 years, 20 years. If today is the day they fall back, please don't let them be a reflection on me.
There you go.
Because then you covered it, but I know we're out of time. One last question for this. If, buyers under contract, they got their 5 days to get the deposit in. We've seen this happen unfortunately in this market. It's day 3, they have to turn the deposit in, and they're like, you know what? I'm not gonna turn my deposit in. I'm not gonna buy the house. You check the box, seller limited to keeping buyers. It's liquidated damages on account. I've heard, I think people think they're safe. Well, they got the money on account, so seller can only keep what they have on account, they have nothing on account. But I've also heard attorneys say, no, on account doesn't necessarily mean like in your account, it means on what you should have paid.
Correct.
I don't see where you stand on.
Yeah, so it does not say in line 587, don't quote me on that, 687, it's right in there. It does not say on account. It says the seller's deposit, and the sellers, or the buyer's deposit. Buyer's obligated to make the deposit. You can sue to enforce that clause and make them pay that first deposit. And you'll win that 9 times out of 10. I don't say 10 times out of 10 because there is no certainty in law. There's a probability, but 9 times out of 10 you will win that. So do not advise your client that, if they miss that deadline, it's okay, they can walk away.
We definitely want to advise them of that.
Yeah. Just know, you should tell them, once you sign this agreement.
Here's the exact one.
Okay.
Seller is limited to retaining those sums paid by buyer, including deposit monies as liquidated damages.
Correct.
So sums paid by buyer.
Yeah,
So
so
they're gonna try to get the loophole, which, like you're telling me, won't work.
Yeah.
It shouldn't work.
there's no loophole because you're enforcing the contract, right? And the contract says you buyer must make that deposit, and so you're enforcing it. Setting aside the whole termination, it doesn't exist, it doesn't matter, you had an obligation on day 3 to post a deposit, and you didn't, and therefore, we're going to force that to happen.
Gotcha.
Yeah. Yes.
So this is my personal pet peeve. And I talk to agents about this all the time. They'll be in a seller's house and they'll take a picture of something that they see and they post it online. And I'm like, and some of it'll be, oh my God, I saw the cutest blah, blah, blah. Or, oh my God, this is the, look at this toilet in the basement. And I'm like, that is a violation of privacy. And if the seller ever saw it, and they're like, oh, it's not, I'm in there, they have their house for sale. It's not a problem.
It is a problem, but good luck enforcing it unless on buyer or seller's agent remarks, you put no photographs for publication, okay? So there you go, that's how you solve that problem, is you write no photographs for publication. And if they breach that, my next advice to you as an attorney is, what are your real damages? I mean, maybe somebody got more excited about the house and bought it, right? But
Maybe they took something, a precious antique in the back and your house got wrapped, like.
okay, so now we're talking, and if there was that happened and you can link the two, yes, there is liability.
They have to prove though that person took the picture.
I just think it's the rudest thing ever, like,
Yeah.
it's my biggest pet peeve.
Just put that disclosure and then, they'll see that when they go to the showing, they'll see that and they'll make sure that they don't do that. And I think it's entirely reasonable.
The legal hotline had, opinion on that as well, it was like, you have been authorized to go show that house, that's what you were showing approval for. Their argument is that is outside of the scope of what you were approved to do.
That's right, yeah, I think that's true, yeah. It's a good point, John. You're not there to publicize the house, you're not there to take pictures of it, you're there to, show the house.
For the purpose of selling.
Right.
Yes.
Yeah, they're not opening up the community, they're opening it up to you and your client. Yes, Cindy?
I think the last thing I wanna say is, thank you.
Yeah,
Thank you.
that's
Regal Club is an office, and he helped us think through some policy, which is very, very important, and he really provided some great outside thinking that we hadn't worked on before, and he's a wonderful resource, and he's so easy to get in touch with. He answers his phone, he calls back immediately, he's a wonderful guy.
Thank you, Cindy, I
Thank
appreciate
you
it.
so much.
I'm gonna leave some cards here for you guys.
Thank you.
If you wanna get in touch with me, please feel free to grab one, and thank you, Cindy, thank you all for having me.
Thank you so much.
Thank you.
So I want to introduce Christopher from Reminder Media. He's our lunch sponsor today. He does have a few samples he's gonna pass around, and I'm gonna put up a quick slideshow that he's gonna go through us, tell what they have to add value to you guys, okay? And then we have lunch.
Well, he didn't say that's
Can I get a what? Oh,
It sounds like this,
There you go,
I can get a next one. Go to where it said the data.
right there.
Nope, next one. There we go.
Okay.
Hello, everybody. Again, my name is Chris Friel, and I'm one of the trainers here with Reminder Media. So I just want to thank you all for giving me a few minutes of your time today. The way our concept works. In fact, I think there's about 10 agents in program with us here. I didn't get the names. Is anybody here using us? Anyone? No? Okay. All right, perfect. So, where our concept works, there's a lot of data from NAR that you can look at. And we like to focus on a few key points here. Next one. First one shows you that 80% of homeowners, they go with the first agent that they interview. And then we're always tracking buyers and sellers throughout the year. Next one. excuse me, 66% of sellers right now, 58% of buyers are finding their agents from a referral or they use an agent they already had a relationship with. Next one. One thing I'm gonna tell you why I know we work. Next one. We've been in business over 20 years and we have an 80% retention rate with agents that try us. But we also have our own real estate team as well. They're a small team of 5 in Lynchburg, Virginia called Acre Brothers Realty. They're with Keller Williams. Last year, they did 250 transactions. Over 50% of them came from referrals. The only referral tools they use is our magazines. Next one. So that's what these are here to do, is keep you connected to your database, whether it's past clients in your sphere or the hot prospects that you're nurturing on a personal level to drive repeat and referral business. American Lifestyle is the flagship. It's all general interest, leisure, art, travel, design, and recipes. Start Healthy is just general health and wellness, mind and body, basic fitness and exercise. Recipes are all healthy. Articles throughout are like how to detox the body, foods that'll boost your immunity, benefits of drinking a half a gallon of water a day, things like that. This third one's called Good to Be Home. This is my personal favorite. My wife is a realtor in Collegeville. It's the one I've been using for her. It's all real estate and home design content. Tips to increase the value of the home, how to stage your house if you need to sell it, things that'll make the moving day easier. There's some seasonal maintenance stuff, and then a ton of different decorating tips and concepts for inside and outside the home as well. The business in action in the corner, they did not have any samples in the office, so I apologize to you about that. That's the newest one. If you ever work with small business owners or investors, that's the one that they'll gravitate towards. Now, you can alternate between these as much as you like. You can do a one size fits all. The next time you send them out, pick a different one if you like it better. Or what we did last year, each mailing now, you can tailor which magazine each person gets. There's a lot more flexibility. Okay, next one. We're gonna take care of the content. That's already done. You have 6 spots to customize. I'm gonna start with this front cover. Picture, contact info, and logo are here, top corner. It's gonna say compliments of you. Now, for each magazine, there's about 15 different cover options you can choose from with different themes. One thing we just did last week, people have been asking us probably for the last 7 years. If you don't like any of the cover options now, we can do a full-blown custom cover for you at no extra charge. So if you want yourself to be actually the front cover, maybe standing in front of a listing or recently sold, or any type of scenery, we can do any custom cover that you want now. Okay, next one. When you look at the inside cover, again, branding is here. There's a letter here that can be tailored to the client. 2 ways you can do the letter if you're a plug and play person like myself. In the portal we give you, we have letters already drawn up you can pick from. They're still going to be individualized, whichever letter you pick, Dear Bill and Judy, not Dear Value Client or Resident, which I know we all hate. If you'd like to edit the letter to make it your own, say you want to take out a paragraph, add some of your own words, you could do that, or you can write the entire letter yourself. If one of your clients had a life event, a milestone birthday, a newborn baby, you just want to specifically address that just to them in their magazine, you can do that as well. Next one. We give these 2 tear-out cards. I call these the ultimate business card. Again, on one side is branding. On the other side, we have so many options you can put on the back. What we found out works the best over the years is recipes. Recipes might not be your thing. We got motivational quotes, trivia games, do-it-yourself projects for the home. Any general subject matter that you think of, it'll be there. If you do have something special that you would like on the back, let us know. We'll do that for you too. Say you want to put the Phillies or the Eagles home schedule there. Things like that, we can do things like that for you. Okay, next one. Now what you're seeing here is the outside back cover. We also give you the entire inside back cover as well. So again, in the interface we give you, there's going to be a lot of real estate template ads you can pick from. But one thing that agents love with the back cover, you can put your listings that recently sold here too. So anytime you have listings, if you want to feature them in the magazine, you can do that. If there are no current ones, but you just want to showcase the different houses you've been able to find and sell for people, that's also an option. This QR code, I'm gonna come back to this in 1 second for you, next one. One nice thing with the back cover though is you can sell it. It's your magazine, you own it. If you like to co-brand, team up with a lender, an inspector, a contractor, any vendor that you know to help you offset the cost, you can do that. Some agents, they just pick one vendor, they'll give them the entire space. Others, as you see here, they have multiple vendors. Next one, biggest thing I want to highlight for you though is why it works. There's a lot of things we can do out there as far as marketing goes. I broke this down into 2 sections. You look to the left, you got your dinners, bottles of wine, gift cards, and baskets, great closing gifts, not cost effective, right? If you try to do these consistently for everyone over a long period of time, we're going to end up working for free. On the right, very cost effective. You got the newsletters, you got flyers and postcards and emails. Now, I don't want to beat this stuff up to an extent. I think everything can serve a purpose at some point, but you do want to maximize your shelf life in the home. So if you think about yourself, you're all in sales, but you're still consumers, you buy cars, furniture, and jewelry, you're going to go home tonight and you're all going to grab your mail, say somebody sends you a postcard or a newsletter. 99% of the time, if you look at it, Where does it end up? If you're like me, it's not gonna make it past your mailbox. I call this stuff lottery marketing. The numbers don't match that day for something that you're looking for, you're throwing out the tickets. And that's the number one reason why agents use this. Get you under the coffee table 100% of the time. It's gonna serve as a visual reminder that you value the relationship. I always say it's like a mini billboard in a home, but our average shelf life is 2 months. So it keeps you top of mind at all times. It's gonna make you look great. The most important thing though, in my opinion, it gives you an excuse to reach out, check in with these people throughout the year and have a conversation. See how they're doing, what they thought of the magazines. Maybe they tried some recipes and things that are in there, but then you can feel comfortable at the end of that call and remind them that you need referrals. Ask them who they know that'll love the magazine like they do, that you can introduce yourself to, that will be buying or selling in the upcoming markets. And I will tell you that we ran these focus groups all year last year. The agents that were in them, they were only sending out our minimum 50 magazines, as long as they made the follow-up calls after the magazines hit and asked for them, we tracked a 31% referral rate. So it's pretty good there. Now that's the nurturing side of this. Next one, there's the prospecting side too. So what I always do for my wife is I send 15 magazines to us. Now in these, I have a bio letter about her in the front, testimonials in the back. We put them in local businesses, both our doctors and our dentists, her hair and nail salon, my barbershop, and our pediatrician. I did list a few others here as well. I just leave one in the waiting room on the table, like a fishing line, because the people that don't look at their phones, they're gonna flip through magazines when they're waiting for service. The rest of them, next one you can hold on to. So when you're going out on listing appointments, do open houses, you're at an event, use it as a first impression piece instead of just handing a business card, because it really adds validity to your brand when you meet somebody new. So your magazines can be customized different ways. They hit different campaigns of your business in each batch. So it's not just like a one trick. One other fun that you'll notice too in the samples, most magazines have dates. It'll say June 26, July 26. Ours are numbered, not dated. And we do this on purpose. That way you don't have to hand them out in 30 days or they're old. You strategically hand them out over a 2-3 month span. They'll last you as long as you need them to, okay? Now just going back, you don't have to flip. Just going back to that QR code a second ago that you saw. We rolled out these custom landing pages last year that'll capture people's info. Now the one I use is a CMA tool. So I have a QR code in the front and back of my wife's magazine. It says if you're thinking about buying or selling, scan this to see if your home is worth. So now wherever we leave them, people are scanning it, it takes them to the page, it'll capture their info. It does give them back the internet value to their home. Now we know the internet's always off with their estimates. She'll follow up, start chatting with them to see what they're looking to do. She gives them the CMA to show them what their house is worth. And since we've done this, she's already got a listing and 2 buyers out of it. So we're getting great testimonials across the board from it. Next one. And the last thing I want to show you before I show you the last slide, which is our numbers. Next one. We have an AI program. It came out almost a year and a half ago called Target Follow-Up. This will take every name and address that you have, and it runs it through these predictive analytics, even down to what people click on and look up on Facebook and Google. It can also identify if they went to websites like Zillow or Realtor.com. Then it scores the database from first to last, telling you who the most prime targets that'll buy or sell in the upcoming months based on the analytics and social media behavior. I'm gonna give you an example on how it works. There's no cap on the amount of names you can run through it. You can have 100, you can have 500 people. I'm just gonna use 100 as an easy number. When we score it, it doesn't score 1, 2, 3, 4 down to 100. It's gonna put them in brackets for you. So your first bracket says very likely to move. The next one says likely to move, then neutral, and it'll continue down. What we found out data-wise over the last year is that 1 out of every 4 people that are ending up in the very likely and likely to move brackets as an average are converting into transactions for the agents. So 25% conversion rate. My wife's gotten 2 from it so far, totaling just under 2 million between the 2. So, and then what I'll answer questions at the end. I'm just going to keep going. What we're doing right now for the summer is we're offering a one-time mailing to students. If you like what you see, you can try this once. There's no long-term contract. Get it out, get it in people's hands. If you like it and you do want to continue like the rest of the agents have, that's our goal. If you did it once and thought, hey, I don't think it's the best thing for me, there is no obligation. We'll shut it right down. Next one. Price per magazine is $4.99 a piece. This includes everything, all printing, all customizations, and your postage and handling. I mean, if you boil this down, it's cheaper than most Hallmark cards out there these days in the store. Our minimum is just $50, comes out to $249.50. You do not pay this up front when your magazines ship. You'll pay for them when they go out. You pick when they go out. If you want them delivered July, August, or September, that's up to you. And then the only other fee that we have is a one-time activation to get going. Normally to start with us, it is $299. When we do these presentations, we knock $200 off. So it's only $99 to start. This is a one-time fee, covers you for life. You never pay it again. Does go to 2 things. You get your own marketing advisor, who's going to be your assistant. They do all the work. Your only job, just get your stuff to the coach. Photos, lists, listings, testimonials, whatever you want in there from your side. Other than that, you'll spend about 15 minutes on the phone picking all the fun things. But they're gonna do all the heavy lifting, the technical and the mailing. And then my favorite thing about us is that we work off exclusivity. The names and addresses that you're gonna send these to, you own them. Which means if any other realtor jumps on board to try to steal your clients, it's not gonna be through us. We make them take their names off, so this will truly differentiate you from every other realtor out there. Your contacts will always be protected. That's it, there's no other fees, there's no hidden costs. Price per magazine will not change on you. When you do get the first one out, you're gonna have a few months to see how well it works, there's no audit roll, we're gonna follow up with you. If you like it, you continue with it, if not, like I said, we shut it right down. Frequency, after the first mailing, there's two options. You can do it once every other month, which is the normal rotation. But if you need something less, we have a quarterly option, once a quarter, once a season. Okay. So that's the pricing. I do have two special things I'm gonna do for everybody as well, but before I throw that at you, everybody understand the numbers or the question of pricing? Okay, next one. So, I'm gonna bring a QR code over here. Don't put out your phones. If you want the trainers here, I don't get to follow up and call through offices like a lot of our sales execs do these webinars. So when I do these, I try to make it a no-brainer for anybody that's interested. If you're interested in trying this once, you can scan this and fill it out. I will pay for the first 15 magazines for anybody that wants to do this to offset your sale. It's gonna be a $74 cash credit. I'm gonna put in there for you when the magazines ship. Instead of $249, you will only pay $174. So I'll take care of the first 15 for everybody who wants to give it a shot. Also, the other thing I have, I'm going on vacation next week, and they always give me a handful of manager credits for managers or broker owners that write their own business. So when I always have some left over, I'm giving them out to the agents, but I'm going on vacation next week, so I have a handful left. If anybody is interested in signing up today, I'm gonna hang around there. I'm gonna give you a manager credit. I can take the activation down today from $99 to $9.99. So it'll be a $10 activation if you sign up today. I'm gonna hang around and then I'll also give you the 15 free because I'm not gonna be able to use these credits next week, so I'm just gonna get rid of them today, tomorrow, and Friday. Yeah, so anybody's interested, $10 to activate, and then, like I said, I'm gonna need 15 on me.
Thank you.
That's all I got.
Thank you.
Awesome.
How long is the commitment?
It's just a one-time trial, so you can test it out, and then it's up to you if you wanna continue. If you do continue, you pick bi-monthly or quarterly, but if you don't.
Then like, is that for a year?
Yeah, we normally do a year, but yeah, so it's just we just, for a year, and after that, it just goes month to month forever. But if the contract would be a deal breaker for you, I can tell you this, I can leave the contract.
Thank you.
Yes.
Can you stay on after you do the quoting? The second and third, going forward, can you just do quarterly or do you have to do month to month?
Well, no, when I say month to month, you can still do it quarterly, but you can cancel it anytime, is what I'm saying.
Oh, right.
Yeah, you can switch your names out, you can rotate lists, change names out, so you can do it. If you need to skip an issue, I've had people, go to Italy for the summer and say.
Well, I can do that, you only did.
Okay.
Yeah, the activation of what?
$10,
Yeah. I did that.
I did this in November, except that I was activated and did this, however, then when it's time to do another one, I would like to stop. And even though it worked, so I didn't do it again. If I, what the reactivate.
Here's what I'll do is you don't have an activation, we'll just scroll over it, just take
Thank you,
$99.
Christopher. You're gonna hang out for a
Yes.
bit?
Yes.
If you guys wanna grab
Can I
lunch,
just take your
Christopher's
card?
gonna be around if you have any questions.
I actually.
Thank you.
Okay. I'll take care of your application. Yeah. You don't have to make it.
Okay, I was like, I don't know.
I'll
if I
I'll be doing your account, like, I'll be doing your account,
Okay, they didn't get it. Thank you. Yeah. Cause I'm like I kind of.
Yeah, and I'll give you a note contract, so if anything's got to do it, we'll.
Yeah, just text me or call me or email me and then we'll just.
Yeah.
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 I was never down to That's just to say. you so much.
And then if I can get.
Thank you.
Thank you.
Yo, what's up? Can you do me a favor? Can you go to Capital State?